Question. Can Representative Nemes, who has touted his desire for more government transparency, explain his support for House Bill 520, which would lessen transparency into the actions of law enforcement, especially in light of what happened with Breonna Taylor and the damning report of LMPD's culture and actions?
Yeah, again on 520, the premise is completely wrong. This is another example of how somebody can say words that sound really damning, but then when you know the facts, they're just not. So 520, as John said, is a bill that said if the investigation is ongoing and someone asks for open records from Middletown Police Department or state police or whoever, if it could impede the investigation, release information about a witness, whatever, then the police department has to articulate the reason, and they don't have to give the records over until the investigation is over, and then at which time it becomes public. No exception for that.
What Jason does not say is that in the list of exclusions of or exemptions from open records law, there is this in 61.878, item H, an exclusion that allows law enforcement agencies already to exclude documentation from open records or other records from an open records request if the disclosure would harm the agency by revealing the identity of informants not otherwise known, or by premature release of information to be used in a prospective law enforcement action or administrative adjudication. In other words, if it would harm the agency, then they can withhold it. That's an important distinction here. In fact, law enforcement agencies were using this routinely to exclude records from public viewing that were not necessarily justified as being harmful to an investigation. And that's where this law has come in. And the reason is this. In September of 2024, after a 4-year battle, the Kentucky Supreme Court said that Shively Police Department violated the Open Records Act in denying records to the Courier Journal for reasons that were not supported by the open records exemptions listed before. In the case, the Shively Police Department categorically denied the Courier Journal's request for public records on the sole basis that these records pertain to an ongoing criminal case. As the Supreme Court said, having reviewed the record, the applicable law, and the arguments of the parties, we hold that Shively Police Department has not proven that it adequately complied with the Open Records Act in this instance. And this is what House Bill 520 wishes to change. This is the wording of House Bill 520 in question. This wording takes that exemption and makes a few subtle changes. It says disclosure of the information could pose an articulable risk of harm to the agency, a change from would harm. And the justification for could harm is a lot lower than would harm. And that's the problem here, is that we already have agencies that are denying records on a spurious basis. This would give them even more leeway to do so. Jason knows this. Jason knows this has been argued about this bill. Jason chooses to ignore it.
Bill also said that if the requester of the records thinks that the police department or the city is withholding records and using this as a way to hold people off, then they can challenge them with the attorney general or go to circuit court.
Hold on a second there, Jason. Let me stop you because you're a lawyer and you know these things. This was a 4-year legal battle pointed out by the court after a prolonged 4-year dispute. The Courier Journal had the right to appeal, which they did, just as everybody else does. That's not something new to this bill. It took them 4 years under current law to get records they should have been given all along. That is not transparency. And what Jason's defending here in House Bill 520 will make this process even harder, because it gives them even more justification to do exactly what they did to the Courier Journal. And it will require a legal battle that most people cannot afford to undertake, or may not know how to undertake, or have the time if those records are of the essence.
I would also note, this is an important fact, again, the premise is just while Kentucky Press Association does not oppose the bill. So if this were to hide the ball, then obviously the KPA would be opposing the bill. So it didn't. So again.
Okay, Jason's a legislator and he knows how politics work. He's very careful to say they didn't oppose this bill, which there are a lot of agencies that come before them and they'll make statements in opposition or in support of bills. And it's probably true that KPA did not officially come out and oppose this bill, but they also didn't officially come out and support it. Jason is a politician. Jason knows how politics works. As he explained to me in the last Cafe Louis forum, I didn't understand it, but I kind of do. Sometimes politicians and sometimes agencies will take a pass on something that's bad, like House Bill 520, because there's something else that they want more and they want to throw their support behind or their opposition against more forcefully to these legislators, and they'll let something else go through. There were other bills that are important to the Kentucky Press Association and indeed the survival of small newspapers. So it's quite possible that they didn't come out and oppose it for that reason, but they did not come out and support this bill. So that's an important distinction here that Jason glosses over when he says they didn't oppose it.
I think this is a very responsible bill, 100% supported. The Senate took out the responsibility. It has not passed. The Senate took out the responsibility that you have to articulate the reasons therefore, and so we're going to get that particular portion back in there. But so that's the situation we're talking about here. When we have an ongoing investigation, we don't want that to be harmed, to go after the bad person, the wrongdoer, or to convict them. And so we protect records for that limited purpose.
To sum up, the premise of the support of House Bill 520 from Jason Nemes is wildly off base here. House Bill 520 seeks to go at this Supreme Court opinion in which Shively Police Department was rightfully called out for not turning over records they should have turned over all along. House Bill 520 will weaken the public's right to know, will lead to even more battles like this 4-year battle for agencies and organizations that can afford to fight them. And for the public who cannot afford to do this, they're just going to be out of luck. For a representative who claims to be for transparency, that seems like an odd thing to support, but that's just who Jason Nemes is.